Okay, Olivia, did you want to go over the agenda just as the intro for this first?
Sure. For those of you who were in our earlier meeting, this will sound oddly familiar. So we are just going to start with introductions so that everybody gets to know one another. I know that some of you have only seen each other once or twice in a couple of check-ins or meetings before, so we'll do that. And then what we are going to want to do is actually get into some of the ideas that folks would like to discuss, some of the topics as they begin to come up. We also want to be sure that we are developing the priorities for the upcoming meetings. So what folks see as priorities, especially for the final report and those ideas that folks would like to discuss a bit further. And then the earlier work group decided to just continue on without co-chairs, but it is up to this group to decide if they would like chairs as a part of this group to kind of lead. And then also the meeting schedule. So we can start with introductions. Mark, take it away.
Yeah, let's start with Brian first here.
How you doing, everyone? I'm Brian Heinzone. I've been with the Department of Corrections for 23 years. Currently, I supervise psychologists in the Risk Assessment Community Notification Unit. I've been in that unit since 2004, so really dealing daily with registration, community notification, cases, questions, issues. That's me.
Okay, and then let's go to one of our co-chairs, Sheriff Troy Heck.
Good afternoon, everyone. I'm Troy Heck. I'm the Benton County Sheriff. I've been a sheriff in Benton County now for 6 years. I've been in law enforcement for 27.
Okay, and then let's go to Janine. And Kendra, if you can unmute her, that would be good.
I got it. Hi, I'm Janine Hebert, and I am currently the Executive Clinical Director at the Minnesota Sex Offender Program, the Civil Commitment Program. I have been there since 2008. And I have worked with juveniles and adults in inpatient, outpatient, prison, and now civil commitment. And it's nice to see everybody. And I'm sorry, I'm going to keep my camera off.
Okay, next, Katrina.
Good afternoon, everyone. Katrina Dexter, Director of Juvenile Justice Reform here at the Department of Corrections. I also serve as the State Coordinator for JDAI, which is the Juvenile Detention Alternative Initiative. Good to see everyone.
Okay, and then one of our other co-chairs, Angie.
Hey, Angie Kiza. I'm the head of the Civil Sex Offender Unit at the Attorney General's Office. Do predatory offender registration, work with the BCA, community notification, work with the DOC, and civil commitment work for counties.
Okay, and then Patty. Let's get that.
Sorry. I'm Patty Wetterling. I've been involved with, I guess I come from a base of a victim of crime. I've been a child advocate for 30 years, and I have great concerns about juveniles on the registry. So that's my primary thrust in all of this initiative, is to try and get them off a registry.
Okay, thank you. And then Nicole.
Good afternoon, everyone. Nicole Matthews with the Minnesota Indian Women Sexual Assault Coalition. I'm the executive director, been there for about 20 years. And prior to that, I was a sexual assault advocate in Mille Lacs County. Nice to see everyone.
Okay. And then Jim Fleming.
I'm Jim Fleming. I'm the Chief Public Defender in the 2nd Judicial District. It's in St. Paul. And it's good to be here.
Okay. And then Representative O'Neill.
Hi, Representative O'Neill. I'm in my 5th term and I've been on the Public Safety Committee since I was first elected. I actually was a part of most of the group subgroup meetings for the CSC working group and was the lead Republican on the legislation House File 707, which became law just a few days ago. And I made a promise to Stacy. I don't see her here, but I'm sure she's coming soon, that I would work and see this through to the end. And so I am here and I'll be at all the subgroup meetings as well.
Stacy's on this subgroup, but she's not here this afternoon because she's in trial.
And then Representative Moeller.
Hi, sorry I'm late. I think, are we just introducing ourselves?
Yep.
Okay,
Yes.
yep. Happy to be here. Kelly Moeller, represent Shoreview, Arden Hills, and Mounts View. And this, I'm gonna have to leave a little bit early today, which is why I was late too. I'm trying to work my other job also.
Okay. And then I am Mark Bliven. I'm one of the coordinators along with Olivia Anderson of this work group. I have worked for the Department of Corrections for 20 years in the area of risk assessment, community notification, working broadly throughout the entire state with Attorney General's office, the BCA, local law enforcement on these issues. Prior to the DOC, I worked with the Board of Peace Officers Standards and Training in the education area there. So working closely with law enforcement for quite a few years. And Olivia.
And I'm Olivia. Sorry, guys, I don't have my camera on. We're having a little bit of internet struggles here with the laptop, but I actually started my state government career at DHS, working in disability services and in aging services. And then a couple of years ago, moved over to the BCA, where I now work with Angie and Katie Myers and others on the registry, as well as do legal analysis and support for the BCA as a whole. So.
And if there are any public members who would like to introduce themselves, feel free to do that. Raise your hand and we can recognize you if you wish. Okay. Okay, then our next issue is to get onto the agenda and look at the issues this work subgroup is tasked with looking at. Did you have anything else, Olivia, on that agenda?
No, the agenda is as it was sent. And so we're just going to ask folks to kind of brainstorm, figure out some of the topics that everybody would like to address in this particular area, specific to the list of crimes to which this the registry applies. I know that there will be a lot of crossover between this, the registry requirements, and additional discussions. So everything will be brought back to the larger group. And of course, if there's crossover, the chairs, Mark and I, can be sure that there are communications between the groups to make sure that that continues to flow. So we just wanted to have folks give their ideas as to what they would like to address here, if there are particular topics that they would like to focus on in the next couple of meetings, if there are particular issues that they find to be of importance as we're discussing this, et cetera. So this is just an open dialogue time for folks.
I jumped the gun on this morning at the wrong committee, but I did bring up that it seems to me the main issues in this, or for this group, for the crimes, is the juvenile issue that Patty brought up. And the other thing that I know Stacy's raised and that's come up in a couple meetings is the same set of circumstances language. So I would say those are the main the main topics that I've heard of that people are concerned about.
Sheriff Heck, did you have any?
I concur with what Angie said, that I think those are the main topics that need to be addressed.
And I think in the same set of circumstances, you know, the main issues have been that people have concerns with are where people are charged with sex offenses but convicted of non-sex offenses. And also one that I see a lot in reviewing cases is the false imprisonment, because oftentimes in a domestic assault situation that's non-sexual, people are charged with false imprisonment and then convicted of, you know, something else out of the same set of circumstances, or that also comes up a lot of times like in a robbery situation. So, you know, the question would be for the legislature, is that something that kind of goes with the intent of the statute in those situations?
Would you like me to pull up that list of offenses that make someone subject to registration? It's what I sent out just about 45 minutes ago, but.
If you want, I mean, does anyone else have anything to say about particular concerns about the types of offenses that are requiring registration?
I have a question, Angie. This is Janine.
Yeah.
Is that okay if I just jump in a little bit? It was helpful for me when Patty gave the context at our bigger meeting. So my question about the crimes that get incorporated is, what's the criteria? And maybe someone could just tell me the history of it. I mean, is it because the offenses, we have historical data that shows that we have found offenders because these types of offenses were on the registry? Is it based on research around risk of recidivism for the types of behaviors? Is it comparable to what other states have, if other states have similar registries? Have they been reactive around like tragedies that, you know, we want to add that in because it was a reactive decision to throw in another type of behavior? I guess if someone could just give me just a really brief sort of, what's the criteria? I'm totally cool with your set of circumstances and looking at juveniles. I do think that's true. I also just wonder if there's an opportunity for us to really look at this, to just sort of see what is our yardstick, and do all of the things that are on there currently meet that yardstick.
So we did a bit of a history of presentation, I want to say last week, as to where everything came from and the incentives around some of the changes. So that PowerPoint is on the website if folks need another look-see at that. In some cases, it was a particular case, a particular crime that incentivized the legislature, as far as we can tell. A lot of this goes farther back than we have particular documentation for as the BCA. It was started as a way to find sex offenders in particular, especially, and this was particularly limited to law enforcement. So at the beginning of the predatory offender registry, only law enforcement had access to the system, and it was to be used for law enforcement purposes. Since that time, not only has the list of entities that have access to it expanded over time for a variety of reasons, but the crimes have as well. And I am, for the other working group that met this morning, I'm looking up a little bit of legislative history to see why there were some changes in 2014. But those that we are aware of and that we noted in the presentation were started because of cases, particular scenarios, particular occurrences. Of course, I'm sure that there are different incentives and reasons why different folks felt that changes were made that I simply am not aware of, or the BCA does not have documentation on.
Okay,
I
Jim.
was just gonna, oh, go ahead. Oh, Jim, sorry.
Okay. I just want to just sort of make some points, having been on the work group on the reform on the crim sex work that we did in the 18 months that came through. What sort of brought about the impetus for this actual work group coming into existence was there was and it wasn't just defense attorneys. It was prosecutors. There were victims advocates that felt that there needed to be, if you were really going to do some reform on criminal sexual conduct, you needed to look at what goes on with the registry. There was great concern about the numbers. Nobody really knew how many people were on the registry. I have no reason to doubt that it's about 18,000. But I have no idea how that number compares with other state registries. And it has this, there just is an element of people get on this thing with certainly a minimal amount of due process, certainly enough to meet a rational basis standard for the enactment of the statute. I get that. But there's people on this registry that had no idea that they were going to be on the registry due to the same set of circumstances analysis, where you might have somebody charged, like they said, on a domestic, and then they threw in a false imprisonment. It was resolved, and then years down the road, this person finds out that they need to register. Now, that hasn't been the standard of my advice to folks. I'm certainly, in my practice, have been aware of what people are on that need to register, but that's clearly not happening throughout the state. And I know that people find out that they have to register based on a probation officer's work with the BCA trying to register somebody after they were sentenced, and they had no idea. It seemed to me that that would be at least fair, at least some element of fairness, that the registration component be a part of the pronounced sentence. If not looking at the complete language. And I know there aren't any prosecutors on this, but there's many, many prosecutors. Well, many prosecutors that would like to see the same set of circumstances language done away with, or to see some meaningful reform with respect to that. With respect to juveniles, and Mrs. Wetterling's much more eloquent about this than I am, but I mean, I've done quite a bit of work in juveniles. What we know now about brain development with juveniles, and certainly the category of offenses that juveniles often find themselves in on a sexual nature, certainly don't seem to match up. And I know that there's going to be some debate about that, but don't match up to that, given that their lack of brain development, about how juveniles find themselves in situations where they're being charged. Now, when we were working on this, we certainly did an look across the 50 states to see where we were at. Minnesota isn't the only state that has juveniles registered, but it's a small number. There's a lot of states don't have their juveniles registered, or there's a registration provision where after the testimony, after a psychological evaluation is done, where then there is a hearing about whether or not that juvenile should register, is a component, but it's not automatically or in the same set of circumstances analysis with juveniles having to register. So there was very much a concern about how the registry has this complete ability to just sort of expand and just kind of mushroom in those who can be on it. And so, I mean, that's what I want to bring to this. I think what we need to see some change on, and I think we need to look at this meaningfully. I don't want to get stuck in traditional models on this. I'm certainly willing to listen to others, but I think that when a lot of the registry was developed, there was a sense of legislative fear, and that we've got outcomes here that are certainly difficult and hard to explain. With respect to the same set of circumstances language, I think Minnesota is the only state in the country that I am aware of that has registration like that. In every other state, you have to be convicted of the offense to register. And it seems that there was, at least when it was passed, some element on the part of the legislature, maybe it was from law enforcement or whatever bureaucratic belief was, that there was no trust in the judicial process and plea negotiation process that the right people would be registered. I'm willing to listen to that discussion, but I think we have to have that discussion again 20 plus years, more than 20 plus years later, since this all came into effect.
Did you want to see a chart of state by state? It's actually a pretty simple map that's available to show relative registration numbers around. It's a couple of years old, but tells that relative.
I mean, I don't know, nobody knows, but I would certainly like that for my own edification.
Yeah, so you can just take a look at this. Can you see that? I don't know if you can read the numbers there, but is it too small to read?
No, I can read it.
So relatively, those numbers in black and parens are the per 100,000. So Minnesota is listed as 317. You look at adjoining states, and South Dakota's higher, Wisconsin is higher, but North Dakota and Iowa are lower. We have the exact same number as Alabama, but you have Arkansas and they're up at 526. So.
And can you tell us when this was prepared? I'm sorry, I can't read the
this was prepared in May 30th, 2018. So it's a few years old, but it's relative. And this was prepared by the National Center for Missing and Exploited Children.
Well, and I think one of the things we talked about from the data standpoint, and Olivia, I'm not sure if this is something that you guys are working on or even can work on, but we talked about getting some numbers on the same set of circumstances, people who are registered just for that. I don't know if that can be pulled or not.
So one thing that we, want folks to be aware of as we're asking for data is the intention behind the creation of this registry system. It was purely intended to find people where they were at that time. It was not intended to be a data pulling system necessarily. It wasn't intended to house criminal history. It wasn't intended to provide anything other than stats on counties, gender, age, those kinds of things. So depending upon what was needed by law enforcement. So we only collect that data that is in the subdivision of 243.166. And I think it's subdivision 4B. same set of circumstances is something that I'm not 100% sure that we can pull for that reason. It's not an item that we were asked to track. And so that's something that I'm going to have to rely on Katie Myers to be able to provide more context around. But know that information as we're discussing any data requests, is that there are going to be issues with data requests that are outside of those items.
I mean, I know that we've asked for it before, and we've gotten some. I don't know how accurate the data was, but I know we have gotten some on that in the past. So I was just curious if there's anything that's could at least be helpful in a, even if it's not super, you know what I mean, just to give us a ballpark even.
And so right now, Katie and the data team are looking at what we can and cannot pull and what we can reliably pull. And so we are having folks go through all of the data points, what is and is not available, and we will respond to all requests as we are able. Just know that the POR registry system is also a system that is for individuals. So when we are pulling data, there may be very well be situations where there are 16,000, 10,000, 8,000 individual files that we would need to go into and check and verify. So there are also going to be restrictions on the amount of time that we have available, at least for the working group to see and use these data points. So just know that context. We will always do what we can to pull what we can.
A couple hands are up.
Patty.
I had a question, two things I want to say. I had a question about juveniles moving in from another state where registry is mandated and how that is dealt with in Minnesota. I know a lot of individual stories, but do they automatically, if they were required to register in Oklahoma, they would be required to register here? Because I'm just ignorant of how it plays out in Minnesota. That's question one. I don't know if anybody has an answer to that.
I can sort of answer that. In Minnesota, for somebody coming in from out of state, first there are requirements as far as how long it is after their adjudication. They have to come to Minnesota within, I believe it's 10 years from either the adjudication or the time they served, when the time they served ended for that adjudication. And then if they meet those time requirements, they don't automatically register if they're registered in the other state. And that's true for adults too. Then there's a separate analysis on whether the crime that they were adjudicated for or convicted for adults is meets the is a similar offense to that requires registration in Minnesota. So in some states, for example, they might, like our basic 5th degree, let's say indecent exposure or indecent exposure to a minor, that doesn't require registration here unless it's a repeat offense situation where, gets up to a felony level. But some other state might require that. So if that person's registering in the other state because of that, but then they come here, they wouldn't register here. Does that make sense?
Yeah, that helps a lot. The other thing that I wrestle with so much, I sent out opinion, but it was designed to help find missing kids, right away. It was a sense of urgency in finding information. But juveniles, when they offend, are most likely, this is why I hate the predatory language, they're most likely to victimize a sibling, a cousin, a neighbor, a classmate, and they tend to have fewer victims than any other crime. So it kind of takes away from, in my experience, there have been some juveniles who have kidnapped and assaulted and or murdered, but that's certainly not very many. And so that it doesn't really play into the initial reason for registry. And what I wrestle with is what what is the upside of having juveniles on any kind of a registry? They need to have their behavior changed and corrected, and their success with that. I see a whole plethora of challenges with it that causes harm to the youth, including a higher risk of becoming a victim of sexual assault. And I just don't see any upside to putting children on a registry. But I just had to say that.
Okay, and Representative Muller.
Yeah, thanks. And I just wanted to circle back to what Angie said at the very beginning about sort of the two areas of focus, and then some of my comments will piggyback off of Jim's comments a little bit. So Angie, I was hearing too from folks who wanted this, that both the juvenile issue is one that obviously we'll consider, and we've already talked a little bit about that today, and the same set of circumstances. For juveniles, it sounds like there are two questions, and one is, do we want juveniles, is it a recommendation to have juveniles on the registry for any crimes, or is it just for certain crimes? And I know one of the things I heard about with the CSC working group was juveniles in respect to the statutory rape crimes, because you might have younger teens and older teens and their sex offenses, but are those, so if you're going to have some crimes, do you want to include those crimes on the list? With respect to the same set of circumstances, I think there is that desire to look at what the different crimes are that are on the list, but also even considering, why does Minnesota even have that? I remember when we did the first large group session, and one of the presentations talked about, I think Angie, it was yours, that Minnesota is like one of a few states that even has the same set of circumstances requirement. And so I'm assuming then that's not a federal requirement for us to have that, if not every state has that. So, and I will say, Jim, I am a prosecutor, my side gig, when I'm not a legislator. I don't make charging decisions because I handle appeals, but I do know from other prosecutors that same set of circumstances can be a challenge, even in charging, because you might be charging out a crime where you want to charge some of those offenses. They aren't sex offenses, but you don't want to charge it because of knowing that registration then would be required. So I've definitely heard that too from some of my colleagues. Yeah, so I think that's all I just wanted to, oh, and one more thing too, Jim, you had mentioned you like the idea of courts perhaps making the pronouncement of registration at sentencing. And I'll just note for folks that courts do make that kind of pronouncement for conditional release terms for sex offenses. So they already are making some kind of pronouncement. So I hear what you're saying about if they would have to make registration too. Courts are used to doing that for the conditional release aspect to sex offenses. That's all I've got.
Yeah, in the same set of circumstances, my understanding is, yeah, we are one of the few, if not the only state that has that language. And that is not something that's in the federal requirements. And we talked a little bit about the federal requirements at the subgroup this morning, and those requirements are tied to federal funding. So we talked about, that's something that we would, make the legislature aware of, but it's a matter of a loss of funding issue if we're not in compliance versus some other kind of consequence. And I know this is just a side thing on federal requirements on the juveniles is we have in our statute the same requirements for juveniles and adults as far as the offenses that apply. The federal requirements are for certain juvenile offenses less than we require, if that makes sense. It's a more select group. And I know in the proposed report from the Criminal Sexual Conduct Working Group, there were some juvenile offenses, but the proposal was to limit them to the most serious juvenile offenses. So we might want to take a look at that language and see, if what we think about that language as part of this subgroup for sure, and the big group overall. And as far as the sentencing goes, yeah, I mean, I would have a problem with making it part of the sentence only because it's a civil regulatory statute, and I think that's going to present a problem. But courts are already required to notify people of the registration requirement, and that does often happen in sentencing orders. That it's usually framed as, register as required by the statute or register as required by the BCA. So,
Sheriff Heck.
I think that the issue regarding juveniles is a matter of sorting. How do we sort out those juveniles who have committed a heinous enough crime that really makes them someone that should be included on a registry because they are likely to reoffend, or because the level of offense is heinous enough that we need to know about them, versus those who have just committed some kind of statutory crime, and this will probably be the only time that they run afoul of the law. And I think that there's been some discussion, and with all due respect to Jim and some others that have brought this up about brain development, I understand the research. I certainly understand from my own life experience and several other people I've seen that the decisions we make when we're below 18 versus the decisions we make when we're 26 are certainly very different. The one caution I would put out there is I want to avoid the idea that, well, these juveniles can't be held responsible for their crimes because of their age. I think that we need to maintain the idea that people do have personal responsibility for the choices they make, even if research has shown that in 7 years they'd make a better choice, because there are certainly millions and millions of juveniles who do not make choices to participate in criminal behavior.
Okay, Jim?
I didn't suggest that juveniles who are convicted shouldn't be held accountable. And then I can't see right now the structure that we have right now that they're not. I mean, they're going through due process, they're being adjudicated. My argument to anybody that would say that registration is almost a collateral consequence of their offense. So I do think juveniles are held accountable in the juvenile setting. Now, there's maybe some people would argue that it's not enough. I disagree with that, but I understand that. What I'm suggesting is that when we put kids on the juveniles, actually, even when we went as far as to create a certification statute, it was out of a climate of let's get tough on crime, and we threw kids on that. And kids have always been treated differently than adults. It doesn't mean that they're not being held accountable. But there is certainly, we've always, up until about 30 years ago, we had a sort of a redemptive position with our children. And so I didn't suggest that they aren't being held accountable, and I respectfully disagree with that representation.
one other thing I was going to mention on the same set of circumstances issue, I'm sorry, Brian, I see you have your hand up too, is, so my understanding is that from the case law is that the reasoning for that, and I think Jim talked about this before, is having to do with people not being able to plea bargain away the obligation to register. That being said, it's also language that has been in the statute for a long time, and I think was initially in the statute when a lot of people didn't really have a lot of experience with registration. So it may be that now, however many years later, 20 some years later, prosecutors, defense attorneys, judges, all are so much more familiar with registration and what that is and what it implies, that it, may be something where that concern about plea bargaining maybe wouldn't be as big of an issue as it maybe was historically, if that makes sense, when it was a new thing. I think then prosecutors would just have to be accountable for their decisions if they do make that plea bargain. So that's just my 2 cents on that.
Okay, Brian?
I just wanted to circle back to something Angie mentioned earlier about the specifically false imprisonment, or if some of the original intent of the registry was to, was to find people that were committing sexually motivated offenses. Just anecdotally, we see a handful, I don't have the numbers offhand, but that are, as Angie mentioned earlier, being charged with false imprisonment in relation to a domestic assault situation, even kidnapping. A lot of times a drug-related kidnapping, we see a lot of those types of offenses, no sexual elements at all involved in the offenses. So it's just some discussion about non-sex related, non-sexually motivated offenses and how we would deal with those, just so we don't miss that piece of it. Related to the same set of circumstances, I've been working in risk assessment for 17 years, and we do risk assessments not based on what the conviction was necessarily, right? We look at the whole dynamics, the whole behavioral situation involved in each situation. And I've seen plenty of folks that have maybe not been convicted of a sex offense that are very likely to reoffend sexually based on all other factors that we've considered. So, just more discussion on that too. It's about maybe not completely wiping out same set of circumstances, but how do we look at kind of risk assessment and including that more in the whole process, if that's possible from a resource standpoint.
Okay. Katrina?
Yeah, I just wanted to point out and appreciate both what Jim and I believe Angie wrote in an email, and really framing the thought process around the registry that it's a collateral consequence rather than part of sentencing, because I think that's really key when we look at our juveniles, especially when we're looking at and potentially are having trouble accessing kids who come on the registry as a kid and then stay on the registry into adulthood, potentially much longer into adulthood. And so I think when we have that frame of mind that it's really a collateral consequence and not part of their sentence, I think that helps me in kind of bifurcating what the outcomes are we're looking for and what the intent is behind the legislation, which then should be driving some of our decisions moving forward. I really appreciated all the information Patty sent out. It was really helpful in knowing that there's a research base in this. I appreciated just my research mind in general, that there was citing so that we can all kind of dive into those research articles further. And I would just encourage everyone, I know it's a lot of work, but when it comes to the kids, there is a good research base out there, and I think Patty's done a really good job of trying to get those things in front of our radar. So just appreciate all those elements.
Okay. Jim?
Just with respect to the same set of circumstances, another situation that's come up with me in my representation is that you pick up a client who's charged with a sex offense that may involve a assault or some other coupled offense with it. The investigation, then you begin to do the investigation, and then you either get a recantation of the sex offense, or that it's very clear from the further investigation that's done that the individual hasn't committed a sex offense. But so then the sex offense gets dismissed, but you're still maybe looking at an assault that the client goes to trial on or pleads guilty to, and they still have to register. And that happens, and there's absolutely no remedy to certainly avoid that consequence, that collateral consequence. And so I just wanted to point that out.
I'd also agree with Jim that it would be ideal if there was a way that we could better sort out some of these people caught up in the same set of circumstance. I think that we all recognize that the people who are on this registry should be the ones that we need to be concerned about and should not be the ones like some of those examples Jim described. I do have a concern about any idea, well, let's just get rid of same set of circumstance, because I work with gun permits on a weekly basis or a daily basis. And one of the collateral consequences of getting a domestic violence conviction on your record is, of course, you're now ineligible to possess firearms. And I see a number of cases that come through wherein the person was charged with a domestic violence, and the case is quite often pled down to a disorderly conduct charge. Now, of course, I'm not privy when I review the criminal history to know all the details of that. Certainly, there probably are some of those cases where the disorderly conduct was the appropriate charge, but there's also the possibility that that was a plea arrangement made to avoid collateral consequences. So I just want to be cognizant of that reality out there too.
Well, and just so people are aware, there are a bunch of different ways that people have challenged the same set of circumstances. So even though there's not a provision in the statute, the procedure in the statute, I've seen it challenged. Well, there has to be probable cause for the initial charge. So if there's a contested probable cause or probable cause isn't found in that charge, I've seen it challenged that way in the initial case. I've seen it challenged in failure to register cases where they say they can't meet the requirement that I'm required to register because it's not same set of circumstances. We see it raised in lawsuits all the time when they sue the BCA on whether they should be required to register. That's come up in several of those lawsuits. People have raised it in risk level appeal cases, saying the ECRC shouldn't have assigned me this risk level because I shouldn't have to register because it's not the same set of circumstances. So while there's not a statutory process, and maybe that's something that should be considered, there are a bunch of ways that can and has been challenged over the years, either in criminal cases or civil cases.
Sheriff Hecht, did you have another thing you wanted to say? You're just super pumped to be here.
Sorry, I will lower my hand now.
Okay, so just to review what we've discussed to make sure we're all on the same page, we've discussed the topic of juveniles, what they should register for, how long, if there are limitations on time. Same set of circumstances as a general topic when it comes to this issue. Registration as sentencing and judicial decisions on that, as well as whether the registrable crime should be sex crimes or sex-specific offenses, and then risk assessment determination of offenders, and whether they should register, etc. Am I missing anything? Are there other issues that folks would like to speak about? And I will send this list out to folks so that we have this for the beginnings of our next discussion. Oh, Nicole, I'm so sorry.
That's okay. Thank you. And this is just kind of going back a little bit to the issue on juveniles and juveniles being on the registry. I wonder, Brian, you told a really impactful story this morning on our requirements work group about a 16-year-old that was put on the registry, and I just wonder if maybe you want to share that again. I know it had, a lot of connections with the requirements work group, but I think it really, says some of the harms for when we are putting our young people on the registry, and it can be for, so many years. So I just wanted to know if maybe you could share that story.
Sure. Yeah, so the story I told before was there was a guy, a 16-year-old kid at the time, convicted of false imprisonment, certified as an adult. I don't recall the details of the offense offhand right now, but this was back in about 2005. Certified as an adult, did not go to prison at the time though. And then I think must have done something, I don't know, again, to trigger his registration over the ensuing years. Now just came to prison in 2021 for the first time as a 30-some-year-old adult for a burglary, second-degree burglary conviction. And because of his registration and certified as an adult on the false imprisonment, this was not sex-related in any way. He is subject to community notification, so he'll be assigned a risk level upon leaving prison in 2022. And then registration will be re-triggered for 10 years until 2032. So we're looking at, by the end of the registration, if it isn't extended again for any reason, 26 plus years for an offense committed, non-sex related offense committed when he was 16. So, yeah.
Jim?
I just thought with respect to same set of circumstances, when you get into those situations where you have a dismissal of the pending charge, let's say after there was a finding of probable cause, I don't know why we couldn't at least explore the possibility of maybe making a judicial finding of whether or not same set of circumstances would be warranted by having the judge make a determination on that other offense as to whether or not there should be registration, as opposed to just making it the job of the BCA or the probation officer corralling somebody in to do that. That's what I was driving at.
So in terms of the judicial branch, this is the one working group they chose not to be a part of. So I will call them and just be sure that they're aware of these discussions and so they can be a part of it. There may be things that I simply don't know. And so I want to be sure that they have the appropriate representation in those conversations. So I will be sure to include them in invites to make sure that
they won't come.
So, so Jim, are you suggesting something like there's a statute that says the court at the time of sentencing shall make a preliminary determination on whether civil commitment's appropriate? They don't always do it, and it's not necessarily the best time to make that determination. But are you suggesting something in the statute that says at the time of sentencing, a court should, if same set of circumstances applies to the conviction, the court should make a determination on whether there was probable cause for the initial charges?
Yeah, basically having the judge make the determination as to whether or not there should be registration off of that, the same set of circumstances situation. So rather than just going right to it, where, the dismissal, or let's say there's a false imprisonment or a sex offense, that the judge makes the determination that the same set of circumstances would warrant registration. And they make
so not just whether it is the same set of circumstances, but kind of whether it is the same set of circumstances and whether registration is appropriate.
Well, if it's the same set of circumstances as applied to the statute, I'm assuming that they would say you have to register.
Okay.
I'm not, I'm not nuancing the language of the statute. All I'm just saying is that giving the judge some indication about making that finding.
Okay, are there any other topics that folks want to be sure to address in the coming weeks? It sounds like we are going to want to, and please provide me feedback on this. How do folks want to start going through this list? Do we want to look at the statute? Do we want to, as of right now, juveniles, this does apply to juveniles, as you all are aware of. And so where do folks want to start with addressing some of these issues? In other groups, it has been fairly easy because we're talking about the statute. We can pull up the statute next time and we can go through it and see what folks think as we continue to scroll through it. What do folks think would be the best way to start on some of the issues that you've brought up? And Jim, I think you're raising your hand.
Yeah, I think with respect to juveniles, that's really a policy consideration that we're kind of charged with. I don't think I mean, we know what the statute says. It's whether or not we're going to be in a position to say, should juveniles be on this thing? Or should a portion of juveniles not be on the registry? And if what juveniles should be on the registry, what kind of cases those would look like if we were going to go down that path. But I think there's a feeling that we should not have juveniles on the registry. Now, maybe that's not the right answer. I'm just trying to articulate or try to define our path here. But I think that's something that we need to look at. And it's really a policy decision at that point. With respect to the same set of circumstances, we may have to drill down a little bit on the language. There may be some of us that think we shouldn't have same set of circumstances, or it could be nuanced. Like, as I said, that maybe judges should make a determination about situations where someone is facing a possible same set of circumstances where there's a judicial finding and what that might look like.
Patty?
Maybe I wrote this wrong, but I wrote down that we have the same set of circumstances for juveniles and adults. Is that kind of
We
right?
do.
Well,
Yeah.
that I think needs to be addressed, because in every other aspect of life, it's different for juveniles. For example, like the military will not put any of their children, Army, Marines, all across the Department of Defense, doesn't allow any juveniles to be put on a registry within that system because they're not adults. And I think that the knowledge base that we have now is far different than when some of this was started. And I think juveniles deserve to be treated differently. I just don't think it's fair to have them meet the same judgment as an adult offender. For example, the man who kidnapped Jacob and murdered him is far different. He'd be a sex offender now, far different from a 17-year-old who gets drunk and even maybe assaults somebody somewhat violently. They're still different. They're very different. And I don't think that having them being judged by the same set of circumstances is fair. But one of the things that I think that we need to do as this group would be to provide the legislature for some of the language, some of the reasoning why, because the public has this sense of safety around registration. Like, that's going to make me safe to know everybody who's in my community who's ever done these offenses. And it's not really, it's like I said yesterday, so many of the offenders are not on a registry. Sandusky was never on a registry. The gymnastics coach was never on a registry. It's like there's many people out there that aren't on a registry. So I think there's a false sense of what it does. And in terms of the sheriff, some of these really violent, horrific crimes, I think we all want them to be held accountable. If kids are not held accountable, nothing's going to change, and they may continue that behavior. But I think the crime will determine the sentencing. But if it's a really horrific crime, being on a registry is a piece of cake. It's not that's not, it's kind of a soft addition for those people. it doesn't really, I don't really think it accomplishes what we want done. We want these people to be accountable and possibly serve time for these crimes, depending on the age. But what we really want, I think what the general public really wants is to build, how can we make sure that our communities are safe? And in many instances, I don't think that putting up people on a registry, especially for juveniles, where there's research to show that kids connected to community are less likely to end up on the juvenile justice system. So when these kids get out or they get past that registry thing, that sense of connectedness is really one of the most protective factors, and we're taking that away. We're taking that away from them ever, achieving success in their lives in terms of jobs, housing, relationships. We're just kind of cutting out the basic needs that every human being has, but it more impacts juveniles. But I think we need to discuss, if we are going to make a recommendation, I think that we're going to have to create the language behind it to justify, so that everybody knows we're not being soft on these guys. We are being fair, because juveniles are different than adults. I don't think they should have that same language.
Well, and I do want folks to know that we are going to put, what's agreed upon and also dissents, and note both sides of things. I know that has been a concern that has been raised a couple of times. So please don't feel as though opinions will be left out, perspectives will be left out if there isn't complete agreement, et cetera. Both sides and votes, et cetera, will be shown.
That's why I'm so appreciative for this discussion, because I think that everybody benefits from it. Let's really dig down on what we're trying to do in terms of building safety and stopping these crimes. So thank you.
So it does sound like we are kind of starting to get into the discussion on juveniles. Folks can continue to have this discussion. We do have about an hour left, but before we get back into the weeds, I do want to discuss scheduling, as I know there are some folks who may have to hop off a little bit early. We are planning on, at least for now, unless folks have a preference or a change, planning on holding these meetings from 1 to 3 on Mondays. And unless there is a change or a request, we'll plan on holding them every week, with the understanding that the week before folks can decide there may or may not be a need to meet, et cetera. If there are any issues with this, please let us know. We're happy to work as best we can with things. And as always, if folks are not able to attend, there will be recordings posted online for folks to listen to at their ability to do so. And of course, Mark and I are always available for questions, concerns, et cetera. Please shoot us an email if anything does come up. But I don't want to stop the conversation. I just wanted to get that in before folks continued. Did I kill it? Sorry, guys. Okay. Well, if there is no more discussion for today, we can always plan on meeting again next week. But we do have, oh, Katrina, I'm so sorry.
Oh, you're good, Olivia. I put my hand up while you were talking. So in regards to just next steps and this work group in particular, this sub-work group, I'd be, if it's helpful, I'd be happy to put together a power presentation in regards to kind of the landscape of other states and kind of what that looks like, if that's helpful for people. Just know that, I'm willing to put any of that legwork in. If folks are looking for something specific on the juvenile side, I'd be happy to do that. And I could probably, I don't want to volunteer Patty, but probably touch base with Patty and make sure it's fully expansive, because she definitely has the knowledge base as well. So happy to do that if folks would like.
That's fine with me. I can also pull, like I mentioned earlier, I can pull what the federal languages on those, on juveniles. I actually shared a link with the chairs, and I can send that out. It's a link I got from the DOJ on the juvenile requirements federally. just so you guys have that information for this group.
I was just going to jump in. I think what might be helpful, I'm willing to help out too, Katrina or whoever, in terms of just recidivism numbers, research related to juveniles. I think we're talking about public safety. Can't quote any specific research at this point, but I know there's plenty out there that talks about very low recidivism numbers in general. And so it might be good just to get that base for everyone
In
to.
terms of, oh, I'm so sorry.
No, go ahead, Olivia.
In terms of recidivism, the only studies that I have seen in are DOC only risk assessment individuals. So there will not be studies as to the entire predatory offender registry. I know Representative Mueller stated that maybe that could be a request by the working group as studies as to recidivism as a whole. But I do just want to highlight that we don't currently have studies on full Minnesota recidivism for the registry at this point.
Yeah, and I think I'm just talking more general, even other states nationwide, about just juvenile recidivism numbers from sex offense standpoint and pulling together some of that information, if it'd be helpful too.
Yeah, I just want to be sure that folks don't think that there's data we can pull on recidivism from the system, because that we definitely do not have. I'm so sorry, guys, but we just don't track it that way.
And I was going to mention to Katrina and if Patty works on it too, that there are some really good resources that I'll try to find an email to you, but there are some really good collections of registration laws nationwide that we used. I used when I was working with the county attorney on a Supreme Court petition. So I'll look for those and send the links over to you, because those are super helpful for comparison purposes. It kind of has all the data in one spot for what the current laws are.
Representative O'Neill.
I just have a quick question. So we had talked about some of the information in the POR is private data. And is that by like the level of sex offender, or is it all juveniles or private data? Just what data is private and what data is public? And
So,
this was created obviously for law enforcement, and now it's way outside of that purview.
so the entire registry is noted as private data. It can be pulled for specific purposes. So for example, law enforcement, as you stated, Representative O'Neill, et cetera, there is a provision in Chapter 13 that allows data to be pulled for summary data or research purposes. So that collection of data can be pulled by researchers for research purposes, those kinds of things, or for summary statistics. So there are a couple of exceptions for that, but it is private data, and therefore in the majority of circumstances, well, in all circumstances where it is not specifically allowed, we do have to get the signature from the individual to be able to even acknowledge that they are on the registry.
Except for there's a provision for non-compliant. So there's
correct, except for the non-compliant webpage, yes.
And then that can only be posted enough information to get them back into compliance.
Correct. And so then as soon as we have them back in compliance, they go off of the webpage and it goes back into private.
Okay, what about level 3 sex offenders?
So level 3 sex offenders, there is the community notification provision. And so law enforcement can pull data for that purpose, I believe. But I would have to look at the statute to get more specifically into that.
And that's covered by 244052. That's a separate statute.
Statistical information on level 3s, actually anybody subject to risk level assignment, we can provide statistical summary information in enough detail. It's what we can't provide is identification, but I don't know if this group needs any identification information, but statistical, we can provide that on.
And I think Katie might have had it in her initial presentation, the level numbers.
Katie did, and I can try and pull that up for you right now if you would like me to. Okay. Please
I
go
mean,
ahead.
aren't there maps or something where you could literally say, I live here and how many sex offenders live around me? Don't those tools still exist?
Yes,
No?
so you can pull by county.
Yeah.
You can pull, I believe also by city. So you can pull maps that will show, or we can attempt to pull a map / just number out by county, where the majority of the population is, where certain populations are, et cetera. It will not be, obviously no private data will be a part of it. It'll simply show general location. And that will be based upon their registration information and how they update that. Patty? Oh, I'm so sorry, Representative O'Neill. Did you have another question? Okay.
I have a question about, I know that there are people who made it their lives, make it their life's work to put sex offenders on registries, and they have nationwide all of this. Once you're on a registry and it is public, you can't really ever, the internet, it never goes away with the internet. It doesn't stay forever? Isn't it a life sentence once you're on one of those public registries?
So in terms of what we store, what we keep, what we allowed to be viewed by the public from our webpage, that is removed as soon as we hear anything else. I can't speak to what others do with that information, but I can speak to what the BCA does, and we do not keep a history on a public website of any kind. It wouldn't be coming from the BCA.
No, I know that.
Yeah.
I'm not suggesting it comes from us, but there is a reality of once something's online, that it stays online. So I guess that's just a factor that we should consider.
And we do have those, we address those issues quite often with the Department of Corrections when those private sources harvest information and then start publishing it. And they're harvesting it from all different types of sources. And people think that that's official, but it's often inaccurate, outdated, things like that. And so I always tell people, warn them about the accuracy of these private websites. But you're right. Once you're on the internet, somebody harvests that information, they can continue to publish it and stays with you forever.
So here's the information that we have as of, I want to say, I believe this was I want to say it was July 1 it was pulled, but I'll have to confirm. These are the stats on offenders by risk level that we have. And obviously this will have changed somewhat since that time, as there will be more individuals who will have either been assessed or those kinds of things. But this is what we have available. And this is also posted on the website. So if folks want to flip back through the PowerPoints, any of the presentations, that is all there as well.
Thanks.
Of course. All right. Okay. Are there any other things that we wanted to discuss? I am assuming that we will start with juveniles next week, that it's going to be an open discussion for the majority of the time, and we'll plan on just keeping notes and going with it as the time goes on. Please let Mark and I know if there are any issues, any problems, any questions, concerns. We're happy to have any and all discussions that we can to make these chats as easy and pain-free as possible. Mark, did you want to open up for public comment if nobody else had any questions or concerns?
Yeah, we can open up if there is any public comment. please raise your hand to be recognized and we will unmute you if you have anything you'd like to say. And I'll say going once, going twice. Our public comment period is closed.
Olivia, I'm not trying to make more work for you, but I am.
Like I said, I'm just the minion. I'll do as I'm told.
In this morning subgroup, you said you would send out the statute with like the areas that group was kind of most focused on highlighted. So I thought it might be helpful, even though we have this nice list of offenses, if you could send out the statute highlighting the list of offenses requiring registration.
Absolutely.
And also highlighting kind of the juvenile aspects of it. And if you need any help, let me know and I can try to help with that too.
Sure thing. I am happy to do that. And I will get that out to you as soon as I can. It will likely be either later today or early tomorrow, but it will be with plenty of time for folks to look over it before our next meeting.
And then I think it would be helpful for everyone in this group to before next week too, to maybe look at the proposal from the criminal sexual conduct group on juveniles, just to kind of see how that compares to maybe what we're talking about too.
Yes, I believe, and Mark, correct me if I'm wrong, if the CSC report is on the webpage.
Yes, it is.
Okay.
Yes.
I'm happy to send out the report again so that folks have it in their email readily accessible. But there are recommendations there. I believe it's in section 2 of the report that have some notes as to juveniles and the registry and what the preferences were of that work group, especially when it comes to discussions that need to be had. Okay, well, thank you all very much for your time today. I know a couple of you, a good chunk of you have been in quality bonding time with me and everybody else almost all day today. So thank you for hanging in with us. We will either see you tomorrow or chat with you later in the week.
Thanks, everyone.
Thank you. Have a good one.